Polity current affairs through static. This discussion includes the current affairs related to polity which happened in the month of November. UPSC rarely asks the news directly. It asks about the underlying concepts which are related to the news. Recently, Supreme Court in Dr. Balram Singh versus Union of India dismissed a petition challenging the inclusion of the words socialist and secular in the preamble. The words socialist and secular were added to the preamble by 42nd Amendment Act. The preamble of the Constitution of India was inspired by the objectives resolution moved by Jawaharlal Nehru in the Constituent Assembly. Preamble basically gives idea of the following objects. First of all, it tells the source of authority, the authority behind the constitution and the authority behind the power of the parliament and the government in India are the people of India. The preamble says we the people of India. See, as you can read, the first line of the preamble says we the people of India having solemnly resolved to constitute India into a sovereign socialist secular democratic and republic. So the people of India are the real authority behind the constitution. Second thing it tells about the nature of Indian state. The nature of Indian state is it is sovereign, which means it can take its own decision. It is not subjected to some other foreign power. It is socialist, means its objective is to reduce social inequalities and to compensate and eliminate the social injustices happened in the society since historical times. Indian state is secular, which means, see, the secular in Western world is a different concept than secular in Indian model. In Western model, secularism means complete separation between state and religion. But in Indian model, the state is not completely separated from religion. In Western model, the state tried to reduce the interference of religion in public sphere. As you have heard and as you have read, in France recently there was a ban on burqa. So in hardcore secular states, the performance of religious activities is discouraged in public sphere, in public places. But in Indian model, the state neither actively encourages any particular religion, neither it discourages any particular religion. It allows room for every religion to grow, and neither it favor any particular religion, neither it discriminate against any particular religion. And the Indian state is democratic. Democratic means the government of the people, by the people, for the people, and the government is responsible to the people of India. The Indian state is republic, which means all the positions of the government, all the public places are open to every citizen. Anyone can become prime minister, every citizen can become president, every citizen can become any person, he or she can hold any office in the polity of the country, in the political sphere of the country. Further, it tells about the objectives of the constitution. The first objective is to secure justice. Justice, what kind of justice? Social justice, economic justice, and political justice. Social justice means to correct the social injustices and the social wrong which were happened due to unequal distribution of resources. Some sections were more powerful and more influential, and some sections were less powerful and less influential. The more powerful sections exercised power over the less influential sections or depressed sections. So there is a stark inequality between social sections in the society of India. So social justice means to reduce that inequality and achieve an egalitarian society. Economic justice means to provide equal opportunity to everyone to participate in the economy and grow economically. And political justice means to provide equal opportunity to every person in India, to every citizen in India to participate in political sphere. See, there is right to vote, which is provided equal to every citizen. No citizen has lesser right to vote, no citizen has greater right to vote. Everyone has an equal right to vote. The second objective is liberty. What kind of liberty? Liberty of thought, liberty of expression, liberty of belief, and worship. So, liberty of worship supplements this secular nature of Indian state, which means the Indian state provides equal freedom to every person to practice and profess religion of his liking. And the third objective is to secure equality of his status and opportunity. And fourth objective is to secure fraternity, which is necessary to assure the dignity of the individual and unity and integrity of the nation. Further preamble tells the date of adoption of the constitution, which is 26th November 1949. The constitution was enacted on 26th January 1950, but it was adopted on 26th November 1949. What is the legal status of preamble? In Berubari and Gopalan case, Supreme Court ruled that the preamble is not part of the constitution. But in Kesavanand Bharati and further in LIC of India case, the Supreme Court ruled that the preamble is an integral component of the constitution, but it has no effect on its own, which means preamble can be used by the courts, it can be referred by the courts to interpret various parts and provisions of the constitution and to decide upon various constitutional matters. Next is amendments. Preamble, as it is a part of the constitution, it can be amended under Article 368 by special majority, which means 50% of the members present and voting and 2/3 of the members present and voting. But the basic structure of the constitution cannot be altered. See, in Kesavanand Bharati case, Supreme Court devised the basic structure or the basic features of the constitution. The term secular is part of the basic feature. It is the part of the basic structure of the constitution. The preamble has been amended only once by 42nd Constitutional Amendment Act, through which the terms socialist, secular and integrity were added. Basic features. Secularism is a basic feature of the constitution. Let us discuss some previous year questions. Friends, while attempting questions in the prelims examination, many of us often make mistake to find the right option among the given four options, which sometimes is a wrong approach. The right approach is to find the wrong answers, to find the wrong statements among the given statements, and by eliminating the wrong statements you will eventually lead to the right statement, which will be your answer. Let's discuss previous year questions. Our first question is economic justice as one of the objectives of the Indian Constitution has been provided in. It is very simple question, but for a beginner who has not read the preamble or who is not remembering the preamble very well, the question may seem a bit difficult, but don't worry. It is very easy to find out the answer. Just read all the statements one by one. Option A, preamble and fundamental rights. See, as you have read through the book of polity, fundamental rights seeks to secure political democracy. Okay, it does not talk about the economic justice. It merely states the fundamental rights which are available to the citizen of India. So, fundamental rights preamble contains economic justice. Yes. Fundamental right contain economic justice. No. So this statement will be wrong. Option B, preamble and directive principles of state policy. Preamble contains economic justice. Yes. Directive principles of state policy is the contains economic justice as the objective. Yes, because from article 38, 39, you will see there are provisions to ensure economic justice, to promote economic justice. So this option is seems to be correct. Okay, then let's come at option C, fundamental rights and DPSP. We have already discussed fundamental right talks about political democracy. It does not talk about economic justice. So this statement would be wrong. So the correct statement is option B. Next question. To uphold and protect the sovereignty, unity and integrity of India is a provision made in the. This question was asked in 2015. See, by first reading this question, it would seem very obvious that the preamble would be the answer. But no, there is a catch. You need to read between the lines in the questions in the paper. Otherwise, you will commit mistake. So, the catch here is to uphold and protect. Yes, preamble contains the three words sovereignty, unity, and integrity. But these are its objectives. In preamble, these are objectives. Okay, but the statement says to uphold and protect. What will you uphold and protect? That thing that you have already achieved. So the preamble would not be the right answer. And fundamental rights? No, fundamental rights is not the right answer because it does not talk about the sovereignty. It does not talk about the unity and integrity. Is the directive principles of state policy is the correct answer? No, because it talks about the economic democracy. It talks about the economic democracy. It does not talk about the sovereignty, unity, integrity. So the right answer would be the fundamental duties. Next question. Which one of the following objectives is not embodied in the preamble to the Constitution of India? You have to identify which among the following is not mentioned in the preamble. See, we have seen liberty is the objective in the preamble. So the liberty of thought is mentioned. Yes. Liberty of expression is mentioned. Yes. Liberty of belief is mentioned. Yes. Liberty, economic liberty is not mentioned. But suppose you do not know this. Okay, then how to reach to the conclusion? You have to find the wrong statement in among these four. See, preamble talks about economic justice. Okay, so how, who will you provide justice to? A victim. If there is a victim, that means there is something wrong happened to him. Okay, so it means you will have to correct those that wrong. While correcting that wrong, you will have to restrict liberty of someone or something or some entity. See, the fundamental concept of liberty is you have the right to do anything you want, but there is a catch. While exercising your right to liberty, you should not infringe upon right of liberty of others. Okay, so while ensuring economic justice, there must be some restriction of liberty of something or some entity. So the economic liberty option is not correct, and this will be your answer. Next question. The mind of the makers of the Constitution of India is reflected in which of the following? All these options seem correct at first instance. Okay, so just read the question carefully. The mind of the makers of the Constitution of India. The question, the language of the question is most comprehensive. It It is asking about the part which is more comprehensive, which will reflect the overall ideology or overall idea behind the constitution, the overall idea which was in the mind of the makers of the constitution while drafting the constitution. Okay, so which one is more comprehensive among these four? Is it fundamental duties? No, because it only talks about duties. Is it directive principles of the state policy? No, because it only talks about the responsibilities of the state or the duties of the state. Is the fundamental rights the most comprehensive? No, because it only talks about the rights of the citizen and the people living in India. It does not talk about the duty of the state. It does not talk about the duty of the citizens, but the preamble is most comprehensive here. So the preamble is the right answer. These three are wrong statements in relation to the question, but the preamble is most comprehensive, hence it will be the right answer. Next question is very factual. See, it asks about the what will be at the place of x. It has stated the preamble as it is and asks about what will be at the place of x. So it is asking about the date of adoption of the constitution, which is 26th day of November 1949. Next question. The preamble to the Constitution of India is. In 2020 this question was asked. This question was very difficult during exam papers. Okay, so let us attempt it. As we have discussed previously that in Kesavanand Bharti case, the preamble, Supreme Court ruled that the preamble is a part of India, but it has no legal effect on its own. It can be referred to by the courts while interpreting the provisions of the constitution and deciding upon the matters related to the constitution. Okay, so let us read statement one by one. First statement is a part of the constitution but has no legal effect. Okay, a part of the constitution, yes, has no legal effect. It seems to be correct, but we will keep it aside. Okay, we will not decide it at the moment. Second statement, not a part of the constitution. It is wrong here. So this statement would not be correct. A part of the constitution and has the same legal effect as any other part. No, because Supreme Court has stated it has no legal effect. Okay, so this statement is wrong. A part of the constitution but has no legal effect independently of other parts. See, between option A and D, which option seems to be more correct? Okay, if the preamble has no legal effect, it means it cannot be referred to by the courts in any matter. Any matter related to the constitution or the provisions cannot be decided by referring to the preamble of constitution if it has no legal effect. Okay, so this statement comes wrong. Okay, this statement is wrong, and the remaining option is D, which will be the correct statement. Other than the fundamental rights, which of the following parts of the Constitution of India reflect the principles and provisions of the Universal Declaration of Human Rights? This question was also asked in 2020. See, you might have not read the human rights, Universal Declaration of Human Rights. It is very much possible because it is not expected from you to read everything. Okay, but we can use common sense here. See, what could be the human rights? There are some basic human rights: right to life, right to property, and right to liberty. These are the three basic rights that every human needs. Okay, so which of the three statements includes these rights? Does preamble contain right to life, right to liberty, and property? Yes, because it contains justice, social and economic. It contains liberty. So liberty itself contains right to life and property. And directive principles of the state policy, yes, it contains these three rights. And fundamental duties also impose duties upon the citizen to protect and promote fraternity. So all these three statements are correct. So if you are not able to reach to the conclusion, just mark all the three correct, because the question is asking on the positive note and all the three elements are positive. Okay, next question is one common agreement between Gandhism and Marxism. See, such questions may trouble you in the prelims. Regarding these questions, you might have the idea regarding the basic ideologies such as socialism, communism, capitalism. Okay, these you will cover in society part while preparing for mains. So basic ideology of Marxism, which is socialism. The objective of socialism to achieve a stateless and a classless society. Okay, and Gandhiji was also influenced by Marxism. That's why he has given the idea of democratic decentralization or the local self government. He also talk about the egalitarian society, which is devoid of any classes. Okay, so one common agreement between Gandhism and Marxism would be final goal of a stateless society. Yes, this is one common agreement. Further, class struggle? No, because Marxism talks about class struggle. In order to achieve a stateless and classless society, the proletariat or the labor class will launch a revolution against a capitalism state, a capitalist state, thereby achieving a socialist society. So but Gandhiji always discouraged violence. So class struggle is not a common agreement between Gandhism and Marxism. Abolition of private property? No. Yes, Marxism tried to abolish the private property, but Gandhiji was not altogether opposed to private property. It is also reflected in the seven sins which were highlighted by the Gandhiji. The first sin is wealth without work. So Gandhiji is talking about wealth. So he is not altogether against the private property. Okay, so this option is also incorrect. Option B is also incorrect. And economic determinism. Economic determinism is a philosophical concept which tells that the economic status is the basis of societal and political arrangement. See, during British era, the right to vote, the voting right was based upon some qualifications, and those qualifications were wealth, education, social status. Okay, so Gandhiji was an egalitarian person. His aim was to achieve an egalitarian society, and Karl Marx's aim was also to achieve an egalitarian society. So economic determinism, it cannot be the common agreement between Gandhism and Marxism. So this option D is also incorrect. So the right option remains option A. Next question. Economic justice as one of the objectives of the Indian Constitution has been provided in it. This question was asked in 2013. It is a very simple question. So economic justice is mentioned in, it is not mentioned in fundamental rights, so this statement would be incorrect. It is not mentioned in fundamental rights, so this statement is also incorrect. It is mentioned in preamble. Yes, it is mentioned in, it is not directly mentioned in directive principles, but the provisions of directive principles aim to achieve economic justice. So this statement would be correct. Next topic is right to property. See, recently a 9-judge constitutional bench of Supreme Court delivered a landmark ruling in Property Owners Association versus State of Maharashtra, restricting the powers of the state to acquire private property. So this topic was in news. The UPSC will not ask about the uh, matter discussed in the Supreme Court. It will not ask about the parties which were in the case. It will ask about the right to property because it is the related concept to the news. Let's discuss what was the original status of right to property. Right to property originally was mentioned in the fundamental rights under articles 19(1)(f) and article 31. Initially it was a fundamental right, but after 25th amendment a new article was introduced in the constitution, Article 31C, which protected laws designed to fulfill the directive principles of state policy, specifically in Articles 39B and 39C, from being challenged for violating fundamental rights, including those under Articles 14 and 19. See, while violation of a fundamental right, anybody can move directly to Supreme Court. It is their fundamental right under Article 32. So, during the initial times, the government tried to introduce land reforms and to in order to effectively implement land reforms, private property, private land was needed to be rationalized and redistributed in order to reduce the inequality in land holdings among the people of India. See, during the freedom, at the time of freedom, there was zamindars, both big and small. These classes were holding almost all part of the land. The ordinary people was holding a negligible amount of land. So in order to reduce this inequality, the government sought to introduce land reforms. But the land reforms were challenged in Supreme Court under Article 14, under violation of Article 14 and 19. So the government introduced 25th constitutional amendment and introduced Article 31C. Okay, so what is the subject matter of 39B? 39B comes under directive principle of state policy. Its aim is to allow the government for the redistribution of resources so that anyone does not accumulate use resources while the remaining population suffers in poverty. Article 39C allows the government to prevent the concentration of wealth. It allows the government to promote economic competition in the country. It allows the government to introduce policy that will reduce the economic concentration of wealth by any individual or by any business group or by any entity. The Competition Commission of India, IRDAI, SEBI are examples of such initiatives. Both Articles 39B and 39C combined allowed the government for nationalization of resources. See, during land reforms, the land consolidation happened and land distribution happened. Okay, and during nationalization of coal mines, during nationalization of banks, the private banks and the private mines were taken under control by the government for the public welfare. By nationalization of banks, government penetrated the liquidation or the credit availability to the rural areas and the poor people. Both articles aim to prevent an economic system where a small group control most of the wealth and means of production, potentially leading to social inequality. Both aim to do economic justice. What is the revised state of right to property? A constitutional right. Right to property at the time is a constitutional right under Article 300A. It was Article 300A was introduced by 44th Amendment, under which the right to property is guaranteed to a person. Doing so allows the government to become flexible. The government now has the flexibility to implement the policies for a fair distribution of resources. See, When the right to property was a fundamental right, anybody can challenge directly any policy of the government which was violating the right to property in the Supreme Court. But now you cannot directly challenge the policy of the government in the Supreme Court. You will have to go to the Supreme Court via proper channel. First you will have to challenge it in High Court, then only you can go to Supreme Court. The government can now regulate private property ownership. What are the takeaways from recent Supreme Court judgment? What Supreme Court has decided? All kinds of private property cannot be acquired considering material resources of the community. So the Supreme Court has decided that all kind of private property cannot be considered the material resources of the community under Article 39B. It is to be decided on the basis of its nature. What is the nature of the private property? Scarcity of the property, impact on the community welfare, and concentration in private hands. See, if there is scarcity of some resources and it is necessary to redistribute for the public welfare, then the government can redistribute it. Okay. If there is too much concentration of some resource in the hands of a few people, then the government can redistribute it. And if the nature of the private property is so that it is necessary and the redistribution becomes necessary for the public welfare, then the government can do it, but it cannot do it arbitrarily. In case of intellectual property such as patents, we all have seen during COVID, the governments of different nations allowed compulsory licensing provisions under which the local drug manufacturers were allowed to produce the patented drugs for the welfare of the people, to safeguard the health of the people. Is Article 31C still valid? Yes, Article 31C is very much valid, but a minor catch here is the Supreme Court has ruled that any property cannot arbitrarily be redistributed. It is to be decided on these factors. Article 31A, what does it say? No person shall be deprived of his property save by authority of law. It protects private property from arbitrary executive action. Yes, it protects private property from arbitrary executive action, but it does not protect private property from arbitrary legislative action. Parliament, by making any law, can take away any private property, but by simply passing out an order, by simply passing out an executive order, it cannot take away any private property. Article 31A does not provide for fair compensation if any property is taken away. Fair compensation for property is provided by the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. So, is there any provision for fair compensation? Yes. Does the Constitution provide it? No. The Constitution does not provide any provision for fair compensation. One more concept which is very much related to the topic, which is adverse possession. See, adverse possession is not mentioned in any law. It is not mentioned in any constitution. It is just a legal principle which is evolved by the judiciary over the time jurisprudence. It is a legal principle that allows a person to claim ownership of another person's land if they meet certain requirements and possess the land for a specified period of time, which is 12 years. Suppose any of your relative stay in your house for 15 years, he or she can claim in the court that I am the rightful owner of this place because I have stayed here for 12 years and I am so and so related to this person, and by that relation I automatically become entitled to possession of this property. The Supreme Court recently in State of Haryana versus Mukesh Kumar case ruled that state cannot acquire property by adverse possession. Any private person can acquire property by adverse possession, yes, but state is not expected and it should not acquire any property by adverse possession. Let us see few hypothetical questions which I have made myself. If the statement in suppose in exam, if the statement say state can take away private property for public welfare, yes, this statement is very much true. State can take away all private property for public welfare, no. Now it has to weigh upon the criteria which are mentioned in the Supreme Court judgment, which are the nature of the property, scarcity, impact on community welfare, concentration in private hands. To summarize, legal framework for economic equality, Article 300A, which regulates private property, Article 39C, which prevents wealth concentration through regulatory bodies, 25th Amendment, which introduced Article 31C, which allows the government and protect the laws to implement certain directive principles from judicial review, and Article 39B allows redistribution of resources for economic balance. Let us discuss one question. Question is, match list 1 articles of Indian Constitution with list 2 provisions of Indian Constitution and select the correct answer using the codes below the list. No person, Article 16.2, it is related to economic equality of opportunity in employment. So the first statement is no person shall be deprived of his property. It is not related to Article 16.2. Second statement is no person can be discriminated against in the matter of public appointment on the ground of race, religion or caste. Yes, second statement is related to option A. Let us read the remaining options. All minorities, whether based on religion or language, shall have to establish and administer educational institutions of their choice. It is not related to Article 16 because Article 16 talk about the equality of opportunity in matter of public employment. Further, option 4, statement 4, no citizen shall be denied admission into any educational institution maintained by the state or receiving state aid. It is also not related to Article 16. So only statement 2 is related to Article 16. Let us see among the options. Only two options are correct here. Option A and option C. Okay. C is common in both. Only B and D are differentiating. So let us read B and D. Article 29 and D Article 31 1. Article 29 tells about the interest of the minorities by ensuring their cultural and educational rights. Cultural and educational rights. We have seen option C has related to option C is related to third statement. Okay, the remaining statements are statement 1 and statement 4. So article 29 talks about the cultural and educational rights of the minority, but statement 1 talks about the private property. So statement 1 cannot be related to option B. The remaining option is 4. So the option B is related to statement 4. So the right option here is A. Option A is right answer. That is all for today. We will discuss further current affairs in the upcoming discussion. Till then, keep revising, keep studying, be motivated, remain healthy, and like and subscribe this channel and share and comment if any suggestion you have in your mind. Also subscribe the Telegram channel mentioned in the link in the description. We will need only one more class for the November month polity current affairs. You do not need to worry. You just focus on the static part and keep revising static and practice previous year questions. We will discuss all the current affairs which are relevant to the prelims exam on this channel. Thank you friends. Thank you for listening.